Okay, here we are, 1 o'clock. I think we are ready to go. Thank you for joining us for the April 20th edition of the Real Property Law section of What's Up With Us. I don't know, I guess webinar, meeting, podcast, whatever we're calling it these days. We have a special guest today, Benjamin Schatz, who's going to join us, and we're going to interview him, and we're going to see if he has any commentary on the cases that we're discussing. So let's jump right in and go to our agenda. I can get my slide screen to change. There we go. So we're going to start off with the usual. We're going to say, hey, what's up with April? We're going to start with that. And we've got a couple of cases, Crescent Capital, and then Sheen versus Wells Fargo. Then we're going to do our interview. And we've got a third case, Pantera versus Superior Court. And I saw something that I thought was interesting over the last month. So I just put it up there. We're not really going to discuss it, but I thought maybe some of our members may be interested in a real estate related attorney general opinion. As usual, we're going to end with a list of real property law section activities and events that are coming up, and a reminder of when to join us next month, on May 18th. We're going to have actually another very interesting What's Up With Us. We're having two representatives that one, it works in the city attorney's office, and the other works with a law firm that advises cities. So a kind of a little different perspective on things. So hopefully you can join us next month for that. And let's get right into what's up with April. And this may take a little bit to load because I know there are a lot of graphics in this next slide. So here we go. So what's up with April? I was looking at April and I saw, well, right at the beginning of the month, it's the beginning of Ramadan, and I wasn't aware of that. And then a few days later, on Friday, was starting Passover and was Good Friday. So we got some things going on. But for those of you who maybe aren't religious, maybe you are religious, maybe you're a-religious, maybe you're anti-religious, I don't know. But if you're a real property section member, what else is going on in April? What else is going on is the Real Property Section Health and Wellness Retreat in beautiful Lake Tahoe. And Ashley and I were just discussing that a big snowstorm is coming in. So I think it's going to look a little bit more like the left picture than the middle picture. And for those of us who thought we might be doing outdoor activities, we may be stuck inside in the spa, kind of relaxing anyway. Ashley, I don't even know, I can let you say a word here, but it's only a few days away. Hopefully the roads will be clear by the time. If somebody is still interested in coming to the Real Property Retreat, can they still sign up?
Yeah, absolutely. You can definitely still sign up. And the retreat starts Friday evening with the welcome reception. And then we have activities all day Saturday, and then Sunday is completely free. So we would love to see you there. If you still haven't registered, you still have an opportunity to do so.
Okay, and I've got a link later on. And if you want to put that, I don't know if there's there's a chat box. If you want to put a link in the chat box, that would be kind of nice too. We hope to see you there. I'm going to be there. My whole family's coming up. So it should be a good time if we could actually get there. So we'll see what happens.
Fingers crossed the flights are not going to be canceled for anybody.
Okay, fingers crossed. We're going to make it. We're going to make it. It's going to be a good event, and there's a lot of activities, and there's MCLE too for those who are interested in that kind of thing. So let's start off. Hey, good. Wow, I don't think I've ever gotten to the cases this quickly in a What's Up With Us presentation, 4 minutes. So we're going to start with Crescent Capital versus Motive 8. And let's see what happens. So the first thing I want to make sure everybody notices is that we look and we see this is an appellate division of the LA Superior Court case. And for those of you who've attended past What's Up webinars, I will occasionally put up an appellate division published case. A lot of them tend to come from the LA Superior Court, which of course is the biggest court system in the state of California. And so they are at least influential, if not binding. And maybe Ben can kind of give us a little tutorial about, being our appellate specialist, what's the legal effect of an appellate division Superior Court case. But we'll let you jump into that in a minute, Ben. Let's do a summary of the case, and then we'll start talking about it. So what do we have our facts here? Well, we have Crescent acquired property through a non-judicial foreclosure sale. After Crescent acquired the property, what did they do? Well, they wanted to get the existing property owner or the former property owner out. So served them with a notice to quit, used the language and all occupants residing therein. Ultimately, an unlawful detainer was filed in late February 2020, and a default judgment was entered against Motive 8, the former owner, and all unnamed occupants. Look at this, all the way took to November 5, 2020, right? So September 19, right before 2019, September 11, 2019, right before the pandemic really got going. But, you know, we all know the courts were closed for a while. So it took a little more than a year for Crescent to get a default judgment. Well, lo and behold, right after they did that, December 17th, also 2020, Carla Soto, who was an occupant of the property or claimed to be an occupant of the property, filed a post-judgment claim of right to possession. And she was basing this claim on and we're gonna have to use the word alleged, rental agreement that she had with the former owner of the property. At the hearing on the post-judgment claim, it came out that Soto had been living in the property since September 1st, 2019, so 10 days before the foreclosure sale, pursuant to a 2-year lease arranged by her broker. So you don't often see brokers on residential leases, but the broker was somebody for whom she was performing housekeeping services, and a representative of Motive 8, the former owner of the property. A hearing was held on the post-judgment claim in December. The trial judge, you could tell from the opinion, really had difficulty believing the credibility of Ms. Soto and denied the claim of a right to possession post-judgment. Okay, so that issue was appealed, and it went up, and the appellate court was looking at this and looking at Code of Civil Procedure 1174.3 that allows an occupant who was not served with a pre-judgment claim of right to possession to object to enforcement of the judgment post-judgment. Now, we mentioned in the facts that there was service by post and mail. That was in the record, right? And in the facts it said, it also indicated not just Motive 8, but all occupants residing therein. So there's information in the record supporting that, but the only evidence presented at the hearing was testimony by Ms. Soto. So there was no evidence to contradict, or evidence that was presented at the hearing that would contradict Ms. Soto's contention. And she said she wasn't even aware of the eviction notice until she got the sheriff's posting on the property. Crescent argues, well, regardless of that, a tenant of foreclosure property has to show a bona fide lease exists to be entitled to remain until the end of a fixed term lease. And that's under a different provision of the Code of Civil Procedure. But that is not, the appellate court said, that's not one of the requirements of 1174.3. The only requirement is to establish occupancy and to establish that the person making the claim is not an invitee, not a licensee, not a guest, not a trespasser. So Ms. Soto established occupancy existed at the time of the UD, right? Because she was saying she was there 10 days before. Well, she was there saying she was there 10 days before the foreclosure, so well before the unlawful detainer was filed, okay? And she proved that by providing a copy of the lease, one utility bill, that's it, one utility bill for, I think it was Spectrum internet service. And that was it. And then she provided a driver's license that she had obtained after all of this process had begun. Well, what the appellate court said was, listen, Crescent, what you're saying may be a legitimate argument under 1161B, but that's an issue that has to be contested at the UD hearing itself, not at the post-judgment claim of right of possession. So kind of an interesting, to me, there was a couple of things that kind of stood out here. The circumstances surrounding the lease, I'd have to say we're probably a little bit suspect, right?
For sure.
Very rarely do you see a 2-year residential lease, okay? Especially for, I have heard of them for really high-end properties where like maybe some movie star wants to live in Malibu for 3 years, but not for a modest property that was being rented for supposedly $1,500 a month.
Well, and Neil, they disclosed in the lease that the property was in default when she signed it. So they knew the foreclosure sale was coming, signed this lease probably to get some cash out of this girl for the last few months and to try to delay the whole process. Because she was Spanish speaking only, she didn't speak English. She claimed that the lease was translated to her, but then she only had one utility bill. She suddenly got a driver's license in October to try to prove that she lived there. Paid rent in cash and had no proof of any receipts, So yeah, I can see why the trial court was like, this seems suspicious to me, but.
And the rent she paid, she acknowledged was only for the first few months, and then she just stopped paying. And the lease said she was supposed to pay for utility bills. She never paid for utility bills. And the question is, why not? She said, well, I just assumed, the landlord was paying for them. So there was a lot of things to make this suspicious. But the appellate court said, well, that's not really our issue, though, right? Our issue was focusing on whether there's a legitimate post-judgment claim to a right of possession. Mm-hmm. So I don't know. I see you kind of looking on, Benjamin. Do you have any kind of input, or can you tell us how you think an appellate division Superior Court published case, whether that has any meaning anywhere else?
Well, you've hit the nail on the head on the things that jumped out at me in this case. So from an appellate lawyer's perspective, the exciting issue here is the standard of review question, because the reason the court published this was to say, there's no published authority on the standard of review for this. So we're gonna publish this case. And what's even more exciting is they say, and the standard of review here is going to be abuse of discretion. And then they turn around and reverse it. So it's pretty surprising about how all of this shook out. It's also very important, as you pointed out, to note that this is an appellate division case. It's not a court of appeal opinion. So even though it has a CalApp cite, it's a CalApp sup citation. So there is a citation that you can use to cite this if you want to use this case, but it's not necessarily precedential in any way. It certainly doesn't bind a court of appeal or the Supreme Court. And it also probably doesn't bind any superior courts outside of Los Angeles, because it's just an LA County Superior Court decision from LA County Superior Court judges who are arguably at the same level as any other Superior Court judge anywhere in the state. But if you're in LA County, this is an appellate division decision from that county, and so it's probably going to be followed. But it's interesting that the law is not really very clear as to what is the precedential effect of appellate division cases. And it has never really been resolved to anybody's satisfaction, in part, I think, because there just aren't very many of these. So it doesn't come up very often anyway. But it's a great question. It's one that's crossed my desk many times over the years. And the other thing to note, of course, is that appellate division cases are special sorts of appeals, and the rules are different. So if you think, oh, I know how appeals work, you better think again if you've got an appellate division case, because the deadlines are much shorter and the procedures are different. So those are the things that jumped out at me as an appellate lawyer looking at this one.
Well, thank you. It's always great to have the input. And again, it seemed like an interesting case. This is something that, we might be seeing more of. And I think I get the sense when I review cases every month, and I think you probably review cases every day, Ben, that I see a lot of LA Superior Court Appellate Division cases that they decide to publish. And I'm guessing they're just seeing such an influx of certain types of cases in their division that they probably want to give direction to the Superior Court in their division. That's my guess.
Well, they do get the UD actions, and so there will be more of those for sure in the pipeline.
All right, well, go ahead.
So I thought this was a nice contrast with the next case that you were going to discuss, from the lowest possible appellate court in the state to the highest, right? Because you want to talk about Sheen next, and that's an opinion from the California Supreme Court written by the Chief Justice.
And we do, and I'm going to let Ashley take the lead on that. So Ashley, why don't you go ahead and talk about Sheen versus Wells Fargo?
All right. Well, as you mentioned, it's a California Supreme Court case, and this was just published on March 7th, so very recently. So Sheen, the facts of this case are that Sheen purchased a home in 1998, and he took out 2 junior loans from Wells Fargo after the fact, which he used the property as collateral to secure it. He started failing to make the payments around 2008 and 2009. So he was starting to fall into default under those 2 junior loans. And Wells Fargo sent him, notices and scheduled a foreclosure sale in February 2010. And then in January 2010, Sheen tried submitting applications to Wells Fargo to modify those junior loans. Wells Fargo actually never really responded to him about the modification requests, but did send him the delinquency notices, which ironically didn't say anything specific about foreclosure sale, only about accelerating the loan and warning about negative consequences. So Wells Fargo sold those loans, and in 2014, the new lender foreclosed on those, on the 2 junior loans. So Sheen tried suing Wells Fargo for negligence, claiming that Wells Fargo owed him a duty of care to process, review, and respond to his loan modification request, and that they owed him damages for the loss of his home, hotel and storage costs, and damage to his credit rating. And then Wells Fargo demurred. So the trial court held that Wells Fargo had no common law negligence duty to respond to a borrower of junior loans. And the appellate court confirmed. And so then it was taken up to the Supreme Court for review, and the Supreme Court also affirmed the lower court's decisions. And the Supreme Court decided that, obviously the question was whether Wells Fargo owes the borrower a duty to process, review, and respond carefully and completely to a loan modification request. And the court acknowledged that there was a split in authority in both the state and federal district courts at the time. And Civil Code Section 1714 does not impose the duty to avoid purely economic loss, versus the Civil Code 2923.4, which is under the Homeowners Bill of Rights, which only applies to first lien mortgages. So they discussed a couple different things, the economic loss rule and in the case, and that there was no recovery in tort for negligently inflicted economic losses unaccompanied by physical harm or property damage. So there was no need for Wells Fargo to respond. They cited is it Bianca? Is that how that one's pronounced? I think.
Bianca.
Yeah, Bicanja, sorry. Bicanja case establishing factors for ascertaining a duty of care and saying that only applies to third persons not in privity of contract. So interesting case. And Ben, I'd love to hear your thoughts on this one.
Well, it's a very important case, obviously. It's from the Supreme Court. It was funny when you were telling the history of it, you say, well, it's in the trial court, and then it goes to the Court of Appeal, and then it goes to the Supreme Court. Most cases don't make it to the Supreme Court. It's very hard to get a petition for review granted in a civil case these days. I mean, you're looking at 1 or 2% odds. And so as an appellate lawyer, one of the questions that comes to me is, how do I get my case into the Supreme Court? And what Sheen shows is that, well, one way to get in is, and you touched upon this, Ashley, a little bit, is that there was a split of authority in published cases out there that had been long-standing for many years, starting in 2012, 2013, cases going in all directions. And so the petition for review in this case undoubtedly said, there's a great and the big split of authority, and the Court of Appeal mentioned it too in its published decision. So, how do you get into the Supreme Court? The best way is something like this, where you have an important issue that courts have gone in many different directions, but you have to wait, right? I mean, I'm sure petitions for review were filed in all those other cases over the last 8, 9, 10 years. But this was the one that the Supreme Court finally decided, okay, enough is enough. It's enough of a mess that we need to solve it. So we're going to take it. So it is difficult to get into the Supreme Court, but this case shows one way of doing it. And now that this is the new rule, a lot of cases that are currently on appeal are going to be citing this to try to reverse contrary decisions that were following the other line of authority. And I've got an appeal like that right now. So I'm very much aware of this case, and we'll be using it.
So thank you, Ben. Well, again, great to have, your insight as an appellate lawyer. When I was looking at this case, a couple of things, stuck out to me. One is kind of the timing of this all, right? When did Sheen stop making payments, right? And instead of it being in 2008 or 2009, right? So right when we are entering, right, the Great Recession in California and pretty much the rest of the nation, right? So when did we get this Supreme Court opinion? 2022, right? So possibly 14 years later, there's a resolution to an issue that started when Sheen stopped making his payments either in 2008 or 2009. So the wheels turn slowly, right? The wheels of justice turn slowly. And the other thing that really stuck out for me was both in the decision written by the Chief Justice and in, at least in one of the concurring opinions, there was almost a plea from the justices to say, hey, the big issue here is not a judicial issue. The big issue here is a policy issue, and that's for the legislature to decide. And now that this has taken a while to work its way through the courts, right? Could we be seeing other cases? And I guess we can, because Ben, you said, you were following this. You have, other cases that are at least somewhat related. So we're going to see what happens, and we're going to see whether the legislature picks up on kind of almost a request or a plea from the Supreme Court. Do you have any kind of insight into that, Ben? Do they care?
Well, I'll tell you this, that there are plenty of court opinions from appellate courts that have lines in there or sections or paragraphs that say this is really a legislative issue. The legislature should really fix this problem. We'll reach our decision. We'll do what we can, but we really urge that the legislature step in here and do something. And sometimes that happens, but I think more often than not, the legislature doesn't necessarily take that as an alarm that they need to jump on it. They've got other things to do.
Okay, well, that's good. It's not really an alarm bell that's going off, but it might be a little push that could trigger some action. So we'll have to see. So again, it's interesting case. And the other thing, of course, that was extremely important in this case, which is there's the Homeowner Bill of Rights, and Ashley mentioned this already. That applies only to first liens. And here we're talking about junior liens. And anybody who's in the real estate field knows, before 2008, 2009, people were refinancing their property, taking out seconds, taking out thirds, because at that time, right, there was no end to how high properties could go. And it did not mean anything to anybody, right? That was the area, that was the time or the era, right, where basically if you could breathe, you can get a loan, right? As long as you had some equity or the prospect of gaining equity in the next few years. So, we're going to have to see how this portends for future cases and maybe for the legislature. So a couple of good issues there. So thank you, Ashley. Thank you, Ben, for giving us your insight on Sheen versus Wells Fargo. And now I think we're ready to turn to the formal interview of Benjamin Schatz. And you see Ben here. Ben, you're a partner with Manette Phelps and Phillips. You're a certified appellate specialist. So I'm going to ask you about that in just a minute, which is how does one become a certified appellate specialist? And so I'm going to ask you to talk about that. But first, why don't you just tell us a little bit about your practice, what you do? Do you focus on certain types of cases? Are you a civil specialist? Or do you work in criminal cases? Tell us a little bit about yourself, Ben.
Sure. So I've been doing civil appeals and writs in the state and federal courts for about 30 years now. So within the last week, for example, I won a case in the Second Circuit Court of Appeals out of New York, and I lost one in the Ninth Circuit, which is our home circuit here in California. And I got interested in appellate work because I had a Ninth Circuit externship with Judge Dorothy Nelson out in Pasadena when I was in law school at Pepperdine. I'm a Southern California guy. I went to Palisades High School growing up in the Pacific Palisades, and I went to UCLA for college and Pepperdine for law school. And then I had my big year back east where I clerked for a federal judge in Las Vegas, Nevada. And then I came back to LA and I've been doing appeals ever since. As you mentioned, I'm a certified appellate specialist. So what that means is that after the bar exam, many years later, when I thought I was done taking formal tests, the bar created a new test for appellate specialists. And so I took that test and passed it. It's basically a civil procedure test from hell, unless you're a criminal practitioner, in which case there are two versions of the test. There's a civil appellate and a criminal appellate version. So I did the civil appellate part of the test. And that specialization basically tests basic knowledge of appellate practice, and you also have to have a certain number of oral arguments and practice experience, and you have to continue to renew that every 5 years by showing that you've continued to engage in significant appellate practice over the years. So the state bar certified specialist part of practice is a quantitative practice more than anything else, with a little bit of an educational component. It doesn't, of course, say anything about the quality of the quantity of appellate work that somebody might be doing. So on the qualitative side, I always like to point out that I am a member of the American Academy of Appellate Lawyers and the California Academy of Appellate Lawyers. And those are organizations that are essentially peer reviewed by invitation or application, where work is evaluated for how good it is. And so those are sort of the exclusive realms of appellate lawyers, and I'm active in those places. I'm also ranked by chambers and best lawyers and super lawyers and all of that, but it's really the academies that I think best burnish my credentials. And I'm also something of a bar junkie. So of course I'm going to like the academies and other groups. I'm a former chair of the LA County Bar Appellate Courts Committee, and I'm still on the executive committee for that group. I've been on the LA County Bar Board of Trustees since 2019. And I was also involved in the State Bar Committee on Appellate Courts when that existed. Now, of course, all of those state bar committees are under CLA. And so I'm still on the CLA's Committee on Appellate Courts, which is part of the litigation section. And I'm an advisor to the litigation section, XCOM, because I'm also the editor-in-chief of California Litigation, which is the journal that the litigation section publishes. And I'll put out a call right here for articles. Anyone's welcome to submit an article, and if it's remotely related to litigation or anything that might be of interest to litigators, I would be happy to consider it. So, please send articles that you want to write to me. I'm also the treasurer of the Friends of the LA Law Library that helps supports the LA County Law Library. It's not surprising that an appellate person would be interested in books and libraries. I have a blog that I've been running since 2013 called Southern California Appellate News. And it really covers appellate news from all over the state and federal appellate news as well. I'm the co-editor of a Matthew Bender treatise on appellate practice called Klatchko and Schatz, Civil Appeals and Writs. I've been doing that since 2014. Before that, I did some work on the Ninth Circuit Rudder Guide. I've got a monthly column in the Daily Journal that I've been authoring since 2018 called Exceptionally Appealing, that focuses on appellate issues, but also other issues that are just sort of fun and interesting as they occur to me. I've published well over 100 legal articles, and I've also presented over 100 MCLE type lectures on all sorts of topics, appellate related, legal writing, editing, typography, anti-SLAPP work, ethics, stare decisis, oral argument, all kinds of things like that. But one of the ways that I came to Neil's attention is that I was on the founding committee of the Appellate Court Experience Program, the ACE program, which was a joint project of the LA County Bar Appellate Courts Committee, the Second District Court of Appeal, and the Constitutional Rights Foundation. And that's a program that CRF gets high school students to come visit the Court of Appeal, and volunteer appellate lawyers, or any lawyer who's interested, frankly, will work with the class to talk to them about the case that they're going to watch and the appellate process generally. And then the students get to watch the case in court and then talk to the justices. And then the attorney volunteers go back to the classroom after the decision issues and talk to the students about what happened and what could happen next. So that program's been running since 2005. And in 2008, I was awarded the Lawyer of the Year award by CRF for helping get that off the ground, because there really are a lot of moving parts to get kids onto buses and get them downtown to visit the Court of Appeal and line up volunteers and so forth. But it's been extremely successful. The court's a big supporter. The schools love it. The students seem to get a lot out of it. And then the volunteers have a great time doing it as well. So it has spread beyond Los Angeles. There are a couple other courts that have copied the program and are similarly using that. And Neil has been a volunteer since 2012. And I know you've worked with at least 4 different high schools. So you can put in a plug for the program too.
Okay, I'll put in a plug. It is a great program. Each time I've been involved, and I had the time to volunteer, so it involves a lawyer or 2 lawyers going to a classroom, usually 2 times, maybe 3 times in advance of the actual oral argument, to discuss the issues and discuss the case with the high school students and to get them to think about the issues. Now, each time I did it, and I don't know if it's always this case, but each time I did it, in the case that was being heard, that the students were going to go and listen to the oral argument, happened to be a criminal case. And I don't know if it's always that way or not, but every time I did it, it was a criminal case.
Yeah, it's not, but the criminal cases are often the easiest ones to understand. It's much more complicated if you get, a CEQA case or an anti-SLAPP case. I mean, even just to describe the law to the students is going to take an hour. Whereas if you tell them, this is a search and seizure case, they've watched enough TV to know exactly what that is. So really the court is in charge of finding a case that they think can be digested by high school students easily. And so that may be why you've seen only criminal one. But as I've said, they're not only criminal cases. They're sometimes civil cases with relatively simple fact patterns that make for very good programs.
Yeah, and I think for the ones that I've done, I agree. I think the fact patterns were fairly simple, fairly easy to understand. I mean, I had a couple, so-and-so shot so-and-so. What was the reason for it? Or so-and-so shot so-and-so, but was let off because of some procedural issue. So they were not convicted. And then we would focus on why the law is that way, or what is being argued before the appellate court on that particular case. And how would the students answer it if they were, sitting on the court? And I think one of the things that the students like the most is actually going to court, hearing the argument, and after the argument, the students have a chance to go in and talk to one of the appellate court justices that were hearing the case and either ask them questions about the case or ask them questions about what it's like to be an appellate justice in California, how they got there, what it means. And really, I think part of the point of the program, Ben, and correct me if I'm wrong, is to get students interested in the law. And I think actually meeting with the appellate justices is what really got the kids excited. Talking about the case and the nuances of the case before, while we're in the classroom, and afterwards in the classroom, that was fine. But actually going into the justice's chamber, right? And, you know, making it real to somebody. This is a real person who's making that decision, you know, along with two others. And I thought the students really enjoyed that portion.
They also often speak with the lawyers who argue the appeal, and so that's fun too. But you're right. It's a civics education program, but it's also to get these students thinking about law as a potential career.
It's good stuff, and Ben, kudos to you for being involved in that program from its inception and getting it going. It seems to be very successful. You know, we have another few minutes. I wanted to mention something. You had spoken to me about a case that you thought was real estate related, and we might have had time, you know, to look it up. And it was the Linovich Capo Shores case. And when I was looking that up, I see your name is underlined. I was on Westlaw and I see it was underlined. So I'm like, well, let me see what else, you know, Ben, you know, shows up at. And so I did a search for you, Ben, in Westlaw, and I found 167 cases that had your name, you know, somewhere in it. In addition to all of the other things like briefs and et cetera. And those who have paid attention to us know that at my work for the Association of Realtors, I write amicus briefs. So I'm like, I'm going to look my name up and see if I, you know, appear anywhere. And I only had a modest 67 references, but some of those were to somebody else named Kalen. It wasn't a full 67 for me, but I think almost every one of the 167 were you. So Ben is very active, very involved. You know, you have his contact information on the screen. A great person to talk to, and that kind of, you know.
Yeah. So Neil, let me answer your original question, which was to describe my practice. You know, I've already described my bar activities and some of that fun stuff. But what about my day job? So as I said, I do state and federal civil appeals and writs, and that includes a lot of real estate and land use type cases. As you found, I've got, you know, well over 100 published opinions and, you know, over 55 oral arguments and civil appeals. Spanning the entire state geographically, and I've also worked in just about every federal circuit in the country and U.S. Supreme Court cases occasionally as well. I'm also involved in post-trial motions, which is an aspect of appellate practice, you know, helping to reduce large verdicts or win new trials. And like you, I do a lot of amicus work, some of it paid, a lot of it pro bono as well. I've lately been filing a number of briefs relating to Nazi looted art cases, which is a particularly interesting and hot area related to property, but not real property. On the paid side, you know, the one case that comes to mind is Salome versus Tarsadia Hotel. We did an amicus brief in that. It's a Ninth Circuit case, 726 F3rd 1124. And that was an amicus brief for the Real Estate Roundtable and the National Association of Realtors. And the holding in that we helped get to was that condo sales in the Hard Rock Hotel in San Diego were not securities transactions under California or federal law. I also do a lot of anti-SLAPP work, which does come up quite a bit in real estate cases. And indeed, the classic anti-SLAPP scenario is it involves you know, a community that's protesting against development, and that work also includes expert work, where other lawyers retain me, especially with regard to their fees, to opine that their fees were reasonable. And so I can use my own substantive expertise to build a foundation to say, oh yes, this lawyer is definitely worth all of that money on this particular anti-SLAPP victory.
I'm so interested in your art law cases because last year we had talked about on one of our sessions the Guelph treasure case, and I was following that one and what was happening with that. So I would love to, if we don't have time today, chat with you offline about that because that's really fascinating.
Yeah, I've given some lectures in law schools and other things, and I was almost afraid to mention that because it's such an interesting topic. It pulls us off in another direction. But I'd be happy to chat about that at some point. What I really wanted to do for this audience, of course, is to talk about the realty and land use type work that I do. And that my firm does. We have a particular expertise in takings cases, inverse condemnation and eminent domain. So that's one area. We do a lot of coastal commission related cases, and the Linovitz case that you mentioned, Neil, is one of those. That's from 2021, 65 Calap 5th 1106, and it's a permit streamlining act notice, but in that case had some very interesting appellate angles because there was one published decision that went against our where our client wanted to go, and so the trial judge said, well, I have to follow that precedent. So you lose, but good luck at the Court of Appeal. We go to the Court of Appeal, and the Court of Appeal sees it our way and publishes this opinion that says we reject the existing precedent, and here is what we think the rule should be, which is wonderful, right? It's great to win. Now suddenly we have a split in authority. And so the other side files a petition for review to the California Supreme Court saying, aha, there's a published split of authority. You absolutely need to take this case and resolve it. And that's a scary position to be in when you're trying to hang on to your Court of Appeal win. But we were able to defeat that petition for review. And usually defeating a petition for review is easy. You could do nothing and probably win. But in that situation, you really need to come up with some good arguments for why, even though there is now a published split of opinion, that shouldn't matter, and that the Supreme Court shouldn't take the case. So that's a fun one, and definitely worth another program of discussion for the land use and the appellate angle. We also do a lot of CEQA cases. And the one case that I worked on in the California Supreme Court that I argued a few years ago was the Banning Ranch Conservancy case. That's 2 Cal 5th 918. And we also do a lot of water related cases. We're in a drought, and the water cases are a big deal, and there's a lot of them going around, and it's a very complicated area of law. I suppose that I view that as sort of related to land use and real estate, but maybe that's its own specialty. And then of course lots of miscellaneous real estate cases, including some landlord-tenant cases. I mean, obviously not the little residential stuff, but the really big ones. I've had some fun cases there. HOA disputes involving local area formation committees, LAFCOs. And even some election law work, which is land use related because the developments get political, and then suddenly there initiatives and referendums, but it all comes back to to land use and real estate. But the ones that I've really most enjoyed, I think, and that I do a lot of, are commercial lease cases. Cases where you've got these long, complicated leases, and there's some kind of unclear language in there, or there's bad assumptions that were worked into the leases, or that there were bad cross references in the leases, and so somebody wakes up and realizes that the lease doesn't make any damn sense. I've worked on a number of cases involving shopping centers where you have an anchor tenant that goes out of business, and then that usually invokes something in the lease. Is there a similar anchor tenant? If you have a department store that goes out of business and it's replaced by a gym, is that a similar enough tenant to allow the lease to continue on the same terms? An interesting case I did once in that regard, it was called Radio Shack versus Azusa Pacific University, and that's where a gym moved into a retail facility. And the lease language talked about the same quality of goods being sold at the new tenant, but not the same goods being sold. And so it really came down to parsing every little word to get to the right decision. And then I had another one once where the lease had a provision that said that when the lease is renewed, the rent shall be increased to 95% of the market rate. which I guess makes a lot of sense as long as the market rate always goes up. But it turned out that when this was took effect and renewed, 95% was a decrease, not an increase. And so there was a fight over, you know, if the lease says increase, can you increase to a lower number?
Yeah.
You know, so these are the sorts of things that, you know, parties make assumptions when they're writing their leases, and a lot of times those assumptions are not in accord with reality. So there's plenty of room for lawyers to help. And in fact, Neil, I know one of the cases that you wanted to talk about next is one in which you know, there just wasn't very much attention being paid to the documents, including the name of the parties involved. You know, you have these companies that have their LPs and their LLCs and their Incs, and they all have similar names, and suddenly the wrong name is used, and it causes a tremendous amount of problems. But I guess that's why we all have jobs, right?
And Ben, that's a perfect lead in. I think we could do a whole hour with you, but we got that other case that we want to get to. So thank you. I mean, there's no doubt that you have more than just the practice expertise, that you've got substantive expertise as well. So thank you. Hopefully you're going to stay with us for our remaining case.
Of course.
Good. So let's move on to that.
Neil, what do you think about getting Ben to do a webinar with some transactional attorneys about commercial leasing clauses and what they should be doing to fix those so they don't get on appeal?
If Ben is willing, I think that would be great, and it would be, you know, a good kind of, you know, relationship building with the different types of real estate practice. But let's move on so that we could talk, Ben, with you about that afterwards, or Ashley could talk about that with you when she's talking about the art cases. So we're going to move on. We're going to go to Pantera versus Superior Court, case decided earlier this year. Ben did a perfect lead in. And what's our facts here? The facts here are based on the allegations in the third amended complaint. Really important to pay attention to the names here. So we have Pantera, which is a general partnership, which is a licensed contractor, and they sued Rosedale for work done on property in Bakersfield. The contract, however, did not say Pantera GP. It named Pantera Development LLP. All right. But the LLP does not have a contractor's license. The GP alleged, hey, wait, the GP performed all the work. The GP was named in the permit application, in the permit, and in the certificate of occupancy. But this is a big case. Rosedale refused to pay $2.6 million that was owing on the balance of the contract, right? So not somebody just, you know, putting in a bathroom in their house, right? This is a big case. The LLP filed a mechanics lien, right? Because the contract was in the name of the LLP. And then the GP, Pantera GP, sued to reform the contract and get the balance paid. Rosedale filed a demur. What did the trial court say? The trial court says, well, you've got the contractor state licensing law that requires one who's performing licensed work to have a valid contractor's license if they're going to collect on the work. And they looked at some other cases and said, well, equitable principles are not permitted to evade the contractor's licensing law. Reformation is essentially an equitable principle. We're going to grant the demur. We're going to dismiss the case. Went up on appeal. The complaint, again, was filed by the GP entity. All right. The court looked at Business and Professions Code 7031, the contractor state licensing law. It says, well, if you're licensed, you're not precluded from bringing a claim for licensed work. Whether Pantera GP or Pantera LLP perform the work, that's a question of fact that needs to be decided at the trial level, not at the demur level. One of my favorite quotes of this case is the following. It says, one of the dangers of winning on demur, right, because Rosedale won on demur, is that you are stuck on appeal with your opponent's version of the facts, right? And then the court went on, they actually vacated the demur and said, well, you're just going to have to prove who actually did the work. Was it the GP or was it the LLP? one of my other favorite things about this case is that there's a dissent. I love cases with a dissent. Why? Because they're tough cases. That's what it means. It's a tough case. It's not a no-brainer. People are thinking about it. They're thinking about it in different ways. The dissent, to me, was kind of focusing on sort of a procedural aspect, looking at the allegations in the complaint and then comparing them to previous pleadings. Because remember, this came up in the third amended complaint. So looking at the previous pleadings, the first and the second amended complaint, and said, well, there's inconsistencies there, and that was problematic. Thought it was an interesting case. Ashley or Ben, any comments on it?
Well, I've got plenty to say. I mean, we've talked about how this case arises from some sloppiness in the drafting, not paying attention to the technical names of the parties. But think about how much time and money went into this just from that one silly mistake. And you're right to point out that, you know, all of this litigation, very, very long opinions, including a dissent, which makes it exciting. And I'd emphasize that this went to the Court of Appeal, not on appeal, but by writ. So, you know, this is a writ proceeding, which again is a specialty that requires help. And I would just point out to the audience to look at the who counsel were, and note that the winning side used an experienced appellate specialist. I know that because I recognize the names, but I think that there's a good lesson in that. You know, getting writ relief is very difficult, and they not only got writ relief, they get a published opinion and a dissent. So there's obviously a lot going on here in this complicated matter that wouldn't have been complicated if people just used the right name.
Right, something as simple as that, right? To ultimately be very decisive in a $2.6 million dispute, right? Not an insignificant thing. Should somebody have thought about that earlier? And who should have thought about that earlier? I imagine that Pantera, whether it's the GP or whether it's the LLP, probably had some advice going into a apparently very big contract to do some work. And who should have been paying attention when those contracts were being drafted? A little bit outside of my normal scope of activity. Hey, Ashley, do you have something you want to add?
No, I think you covered it well. Ben covered some good points. Yeah, I agree with you. It definitely should have been more carefully reviewed before they signed a document with the wrong party names. I mean, that's kind of a case in point, big no-no as an attorney.
So it looks like we've got time to talk about that Attorney General opinion too.
Yeah, we do. So just real briefly, let me change our slide here. Thank you for the perfect lead in, Ben. And again, an opinion just released in little last month, and just going to read you the question and the conclusion, not the whole explanation, but the Civil Code 4505A allow a homeowner association with multiple gates providing access to the entire community. Okay. Does it allow the HOA to bar vendors from entering through certain gates? And we don't know what the reason for that was. I don't know if the roads were narrower or if there were certain influential homeowners by certain gates that did not want to have a bunch of trucks rolling through in front of their houses or their yards. But the Attorney General agreed to give an opinion, and they said, yes, a homeowners association may adopt this type of regulation. Okay, the regulation must be reasonable, right? CC&Rs basically and follow-up HOA rules and regs have to be reasonable and comply with applicable laws. And so, Ben, thank you for leading into this case. So we have this Attorney General opinion, and I put up on the top and kind of the orange bar where you can search Attorney General opinions. So we talked about the impact of a appellate division of a superior court opinion. What's the impact of Attorney General opinion?
Well, they're persuasive precedent. I mean, it's not from a court, so it can't be binding. But I like attorney general opinions because as an appellate lawyer, that's a dream, right? You just get to talk about the law. You don't have to worry about the facts. They always say, as they say in this one, we're not really deciding anything about this case. We're not telling you, what you can or can't do. We're not going to get into any of the factual details. We're just going to talk about the law. And so that's something that appellate lawyers especially enjoy. But the other thing I wanted to mention about this is if you look at the opinion, and it's fairly short, the way that it's drafted, all of these legal citations are in the footnotes. Yeah. So, that is a very Brian Garner-esque approach to drafting a legal document. And that's something that, appellate lawyers care very much about, and I care a lot about. I'm very much into typography and citations and formatting. And so, to see this, I would say that while it may be an effective way of drafting something like this attorney general opinion, I do not recommend that lawyers do that for their own briefing, either in the trial courts or in the appellate courts. Because as much as everyone says that they hate footnotes and they're distractions and they're annoying, my view, and I believe, and the majority view, contrary to the great legal writing expert Brian Garner, who's done many wonderful things, but has been on this crusade probably in the wrong direction, is that we're all used to legal writing, including citations in the text, so that as we're reading, we can see what the authorities are that support a given point and what court it's from and what year it's from. And that's part of the way that we absorb legal information. And, there are very few judges or lawyers out there that like the idea of constantly bobbing their heads up and down to look at footnotes, citations.
Yeah, and so there are endnotes. Is that what you're talking about? So they're all at the end?
No, but every citation is in a footnote.
Oh, I see what you're saying. Not in the body of the.
Yes, not in the body of the opinion.
Yeah, I agree. Always having to either scroll down, or for people who write and put things in the endnotes, which is more for articles really, or rather than cases, that gets very distracting when you're trying to get into the flow of an argument. And you don't want to disrupt, if you're an author, you don't want to disrupt the decision maker's flow. You want them to be able to go right through without being distracted in any way whatsoever.
But footnote citations is one of those things that get appellate lawyers very exercised and excited to chat about and debate. So I couldn't let that slip without mentioning it.
Well, I'm glad you did. Let's just quickly, recap what's going on with real property law section. So we have something going on tomorrow. Next week, a couple of items going on. A continuation of the global leasing campaign that's going on. So the next one, April 27th, is dealing with Spain. Some of those have been in the evening. Notice this one is a rerun, and it's in the morning. By the way, you got a good idea for a webinar. Ashley, you mentioned, a good idea for Ben, a good idea for a short article. Last month, we talked about a case. I wrote an article for our RPLS e-news. I got a call just a few days ago about that article. So, it says there, get yourself noticed. So people actually pay attention to these, people read these. As it turns out, as I was going more into this with the lawyer, there was a conflict for me, so I could not have a substantive discussion with the lawyer. But it was really a good point. I wrote an article, didn't really think anything about it. And then out of the blue, I get a call from somebody with a case that I think, after hearing about the case, no matter which way it goes, that case is going up on appeal. And so the attorney who contacted me, I'm sure I'm going to see that name again, because I don't think it matters who's going to win that case in the trial court. The losing side, either losing side, they're definitely going to appeal that case. So, hey, you want to get yourself noticed? That's a good way to do it. You like writing long articles? We have our Real Property Journal. Ashley, we talked about the wellness retreat that's starting on Friday. And I noticed, I think Beth put the login site in the chat box, but here it is again. And, wow, are there time for comments, questions, suggestions? I didn't see any as we were going through. So if you have any, they're going to have to wait till next month. and that we're going to be back on Wednesday, May 18th at 1 o'clock. Thanks, Ashley. Thanks, Ben. Why don't the two of you give your last comments and take us home?
Thanks, Neil. Thanks, Ben.
Thank you very much. And anybody out there, feel free to contact me. My contact information is on the web and was on the slide. So, and Neil, thank you for inviting me. It's great to see you, and lots of fun to do this.
Well, again, thank you for having us, and bye, everybody. We appreciate you joining us this month.